Okay, let's make a start. So good morning, everyone, and welcome to our commercial agency webinar. My name is Suzanne Carr. I'm a partner in the commercial litigation team at Myerson, and I'm joined this morning by my colleague, Robert Brothers. Robert is a senior associate in the team, and we are both specialists in commercial agency law. Today's webinar will be recorded and circulated afterwards in the usual way. And for anyone wishing to revisit the webinar, it will be posted on our YouTube channel. If you have any questions on the topic, which you are happy to share with today's attendees, then please do post them using the question and answer function. And at the end of the webinar, Robert and I will answer as many of those questions as time permits. However, if there are any questions which are specific to you or your business and you would prefer to discuss those on a one-to-one basis, then please do feel free to contact either of us following the webinar. So welcome back to many of you who I know have joined us for previous discussions on commercial agency law, where we have looked at topics such as the valuation of an agent's claim for compensation and indemnity and other entitlements. Today, we'll build on that knowledge and explore some new topics. As we've covered the basics in previous webinars, I don't want to spend too much time going over that, but I appreciate that some of you will be joining us for the first time today. And so the agenda will provide a very brief overview of the commercial agents regulations and the rights and obligations which they confer on both agents and principals, before then moving on to look at the ability of a principal to restrict an agent's rights, the ability of an agent to engage in competitive activity with another principal during the agency contract, and the ability of a principal to restrict an agent after termination. And finally, we'll have a look at terminating an agent for poor performance. So just for a quick run through of the essential points relating to the commercial agents regulations. So whether you are a principal or an agent, it's really important to understand, first and foremost, whether they apply to your business. The regulations are a piece of English legislation, which was derived from EU law. But we retain the regulations as although we're no longer part of the European Union, they continue to apply without amendment as what's called retained law. They govern the relationship between a principal and their commercial agent. So in a moment, we'll come to look at who is defined as a commercial agent. If the regulations do apply to you, they will impose rights and obligations on both parties, many of which are mandatory, so they can't be overridden by an agreement between the parties. One of those mandatory rights is the agent's right to claim a termination payment when the agency is terminated. So how do we identify if the regulations apply to you or your business? The starting point is to turn to the definition within the regulations, which says that a commercial agent is a self-employed intermediary who has continuing authority to negotiate the sale or purchase of goods on behalf of another person, the principal, or to negotiate and conclude the sale or purchase of goods on behalf of and in the name of that principal. So a fairly long-winded definition. But essentially what that means is an agent must be self-employed, independent of the principal, and authorised to approach customers or potential customers to market the principal's goods. It's critical that the agent is selling goods, not services, as the provision of services is excluded from the regulations. The meaning of negotiate and continuing authority to negotiate is interpreted very widely, and it's not necessary for agents to individually negotiate terms or prices of products. Provided the agent builds up a customer base for the principal, they will be caught by this different definition, provided they are selling goods. This means that an agent who does no more than simply introduces new customers to a principal will be caught by the definition of commercial agent within the regulations. Typically, commercial agents will be paid either by way of commission on sales or a fixed retainer, or sometimes a mixture of both. And finally, a common misconception is there doesn't need to be a written contract for the regulations to apply. Provided the agent meets the definition, then it will suffice for a verbal agreement to be in place between the agent and the principal. I'll now hand over to Rob, who's going to look at the rights of agents and the obligations of the principal. Thanks, Rob.
Thanks very much for that, Suzanne, and good morning, everyone. So just following on from that overview of the regulations, let's consider how they operate and what that means for principals in terms of their rights and obligations under the regulations. So if the regulations apply, they provide the agent with rights during the life of the agency and on its termination. And most of you will probably know that the regulations give the agent the right to claim payments on termination of the agency, including compensation or an indemnity payment. And those are usually the most valuable entitlements of any agent's claim, and ones that generate the most exposure for principals, especially if they're considering termination of the agency agreement. It's important to note that the right to compensation or an indemnity isn't absolute. There are circumstances where a principal can avoid liability. For example, if the agent terminates the agency themselves, and that's not due to any fault of the principal, or if the principal terminates the agency because of the agent's serious breach. So the circumstances of termination are really crucial when considering the principal's exposure to agency claims. And we're going to discuss this in more depth in the final section of this webinar when considering termination of an agent for poor performance. The regulations also impose obligations on principals to regulate their conduct towards agents. And specifically, the regulations state that a principal must, in his relations with his commercial agent, act dutifully and in good faith. But what does that actually mean? The authorities say that it's analogous to the duty of good faith owed by an employer to an employee, and the principal is expected not to behave in a way that undermines the trust and confidence of its agent. And some examples of behavior that could amount to a breach of good faith include unreasonably withholding information from the agent, such as details of sales made to customers in the agent's territory, not paying the agent commission when that's due, or underpaying commission or unreasonably withholding it, unilaterally varying the terms of the agent's contract without the agent's consent or even consulting the agent, such as varying commission rates, amending the agent's territory, or removing customers or taking certain customers in-house. That's all important to bear in mind, because although the general position is that a principal isn't liable to pay compensation or an indemnity if the agent terminates the agency themselves, if a principal breaches its duty of good faith to the agent, that could entitle the agent to terminate the agency agreement and still claim compensation or indemnity. And that's because the regulations recognize that there may be certain circumstances where the agent is forced to terminate the agency because of the principal's conduct. The good news for principals is that agents also have duties and obligations, and the regulations provide that when an agent performs the agency, they have to look after the interests of their principal and act dutifully and in good faith. They need to make proper efforts to negotiate and conclude transactions, communicate all necessary available information, and comply with reasonable instructions from their principal. And these obligations are very important because they set out how an agent is expected to perform the agency. And whilst it's not the same as an employer-employee relationship, agents do have a responsibility to ensure that they are acting in the principal's best interests. And a principal can also impose additional obligations on a commercial agent in a written contract. For example, restrictive covenants and non-compete provisions, which are designed to restrain competitive activity and protect legitimate business interests. So, staying on the topic of non-compete provisions and restrictive covenants, let's consider how they work and what issues can arise. When considering restrictions on an agent's rights during the agency, the starting point is that because commercial agents are self-employed, they're generally free to and often do represent several principals at the same time whose ranges don't compete or conflict, and there isn't really any issue that arises from that. But what about competitive products? Can an agent simply take on another agency and start selling competitive ranges? The answer here is no. The courts have confirmed that an agent owes a duty of loyalty to their principal, and the agent can't place themselves in a position where that duty and their own interests conflict, and they can't act for the benefit of a third party without the informed consent of their principal. The practical effect of that is that if the agent was to sell competitive ranges without the principal's consent, then that would likely amount to a serious breach of the agent's duty of good faith and provide the principal with grounds to terminate the agency without having to pay the agent indemnity or compensation. The best way to avoid issues arising here is to make sure the position is transparent. Ideally, at the outset, the agent should make sure their new principal is told in writing that they act for other principals, and any future agencies they intend to take on should be communicated promptly. And if the other principals are not competitors, then there's usually no issue. If the agent intends to sell competitive or conflicting products for another principal, then they should let their principal know the relevant details and request permission. The principal shouldn't unreasonably withhold permission and should consider carefully whether any new range of products the agent intends to sell actually competes. They can do this by comparing the products, the price point, and the intended customer base. And finally, just to avoid ambiguity, the agency agreement should set out what the agent is or isn't permitted to do during the course of the agency. And if there is no written agreement, it's best to set out any restrictions on the agent either by email or by letter at the outset. So another common issue which arises is where an agent acts for multiple principals, and during the course of the agency, one of the principals introduces a new range which competes with a range already sold by the agent. And the agent's often put in a difficult position here. They may be keen to sell the new range if that appears lucrative, or if the agency with the other principal is much larger. Again, the starting point is that an agent can't sell competing ranges unless his agency agreement permits him to sell competing ranges, but that's highly unusual, and we rarely see that in practice. So if permission isn't provided in the agency agreement, the agent needs to seek permission from his principal, who may decide not to grant that because doing so could harm its own sales, and there are commercial reasons for that. However, in some cases, the principal might decide to grant permission, and that's often subject to conditions. And usually the principal does this because they want to keep the agent happy and considers there's no significant harm likely to be caused to its business by the sale of the competitive range. Any permission should be given in writing. It should be confident, or it should be conditional, and ought to be drafted carefully with the benefit of legal advice. And just to illustrate that point, we acted for a client recently where their agent requested permission to sell a new range for another principal they were acting for. There was no question that the ranges were competitive. They were the same type of product. They were going to be sold to the same customers in the agent's territory. And in that scenario, our client was well within their rights to say no and refuse permission, especially where the sale of the competitive range could negatively impact upon its sales. However, there were wider commercial considerations for the client. The agent was a very high performer, and the client didn't want to lose the benefit of that agent and the work that the agent did to the other principal, which incidentally was a much larger business. So there was a real risk there that the agent might move on. So what the client did with our help was to grant the agent permission to sell the other range, but it reserved the right to revoke that permission after a specific date. So that's a good example of a compromise which achieved the client's objective of keeping the agent happy and working within the business, whilst also giving the client the option to withdraw the permission. But sometimes an agent will simply go ahead and begin to sell a new range for another principal, perhaps because he believes there's no conflict that exists between the ranges, and that might go unnoticed for some time. But if the principal learns that the agent is selling the new range and thinks that the new range competes with its own products, then a problem obviously arises. If the ranges are competing, the agent may well be in serious breach of the agency agreement. And at this stage, it's sensible for the principal to seek legal advice on its rights before deciding how to address the issue. The principal might want to sit down with the agent and discuss the position, explaining that the agent isn't permitted to sell the new range for his other principal, and request that he stops doing so immediately. That's all well and good if the agent is agreeable to that, but agents may share a different view and refuse. What do we do then? The answer is the principal will need to consider very carefully whether the agent's activity amounts to competitive activity, which is a serious breach of the agency, and whether they wish to terminate the agency or whether to grant retrospective permission to the agent. And as you can appreciate, there's no hard and fast rule on how to deal with these situations. And as I've just mentioned, there may be wider commercial considerations at play. If in doubt, the best course is always to seek legal advice, because there will be a way to deal with the situation one way or another. And just to wrap this all up, that what I've just spoken about is all relevant during the term of the agency. But can the principal also restrict the agent from acting for competitors after the agency is terminated? The answer is yes. The regulations do permit restraint of trade clauses, provided those are in writing and limited to the geographical area and kind of goods covered under the agency contract. The regulations also state that the term of any restriction must be no longer than 2 years. And as a practical point, restraint of trade clauses are controversial, as arguably they prevent the agent from earning a living. And if they impose unreasonably onerous restrictions on the agent or are too wide, they may be found to be unenforceable. So when you're considering restraint of trade clauses, you need to make sure that they go no further than what's reasonably necessary to protect the business. So moving on to the final section of this webinar, I'm going to hand you back to Suzanne, and Suzanne's going to discuss when a principal can terminate an agent for poor performance and give some practical advice to principals on how to approach performance issues generally. Thanks, Suzanne.
Thanks, Rob. So as Rob has just been talking about earlier, there can be circumstances where a principal can terminate an agency agreement and avoid paying the agent compensation or indemnity. But this only arises where an agent is in very serious breach of an agency agreement, and that gives grounds for the principal to terminate on what is known in the law as repudiatory breach. We're frequently asked to advise on performance issues, and often the principal is keen to understand whether the performance issues that they're presented with, whether they give rise to a basis to terminate the agent and avoid paying the termination payment. So I'm just going to have a look at what a principal can do in that situation. It is fair to say the majority of agents do a really good job for their principals, and that makes sense because agents have an economic interest in building up a customer base for the principal and making as many sales as possible. So there's an incentive there for the agent to do the best job they can, which increases their commission. But sometimes poor performance issues do arise, and they're not the norm. But from time to time, we're faced with these issues, and it's helpful if a principal does understand their rights in such a scenario, and also how best to go about addressing those concerns from a practical perspective. If poor performance isn't addressed, it can often lead to a breakdown of trust and confidence between the principal and the agent, and that then can lead to further problems. So in our experience, it's best for the principal to deal with the issues head on. So just having a look at some of the common performance issues that we tend to see. Firstly, we have agents who aren't visiting customers regularly enough, or sometimes even at all. Agents who aren't responding promptly to inquiries, or sometimes not responding at all. Agents not actively marketing products in the territory which has been assigned to them. Agents who are failing to open an acceptable number of new accounts within their territory. Agents who are not attending internal strategy or sales meetings or trade exhibitions when they're being asked to do so by the principal. Agents refusing to follow or ignoring the principal's reasonable instructions, such as a failure to submit monthly sales reports or to follow up on leads for new accounts. And finally, we've got agents who aren't meeting agreed sales targets. Now, each of these on their own can amount to a breach of the agency agreement. If there is a written agency agreement, then it's often very clear that there has been a breach because there's a breach of an express clause. which places a clear obligation on the agent to do something, and that agent has simply failed to meet that obligation. For example, an agreed sales target. But in other cases, the breach might be less clear, and that can often be the case if there's no written agency agreement and the terms of the agency are less clear. So the challenge that principals have is that whilst they may have a clear contractual basis on which to terminate the agent, for example, there may be a clause within an agency agreement that says if the agent fails to meet a sales target, that will provide the ground on which the principal can terminate the agency. But the breach might not be sufficiently serious to amount to a repudiatory breach. So what that means is whilst the principal can go ahead and validly terminate the agency, it may not avoid the obligation to pay the agent a termination payment under Regulation 17. It is difficult, but not impossible, to terminate an agent on the basis of poor performance alone and avoid having to pay the agent compensation or indemnity. So if we do have poor performance issues, we must be very careful about making that decision to terminate. So at this point, principals will often say, well, how can that be fair? How can I have a situation arise where my agent has failed to meet expressly agreed sales targets, yet they're still entitled to compensation or an indemnity if I terminate their agency agreement? And we agree it can often seem extremely unfair, but we're faced with the regulations, which are an extremely agent-friendly piece of legislation, and they provide agents with a high level of protection from termination. So it sets the bar for principals to be able to terminate for serious breach at a very high level. And as I just mentioned earlier, that's not to say that a principal can never terminate on the basis of poor performance, but it's difficult to do so and therefore must do so with caution. So how does a principal approach an agent who is performing poorly? So agents aren't employees. By their nature, they have a high degree of autonomy, and expect to be left to get on with the job. So when faced with issues of poor performance, it can be difficult to face this head on. And often a principal can find resistance from the agent. But the best approach, we would always say, is to just grasp the nettle and address those performance concerns directly with the agent as soon as possible. Don't be shy about telling them where their performance is lacking, what they need to do to improve, but also how you as the principal can support that. Where an agent accepts they're not performing as expected, we find it's often met with reasons to justify why that might be the case. For example, there might be issues with the principal's product availability or a lack of new products, which are resulting in a lack of uptake in the principal's ranges by retailers. Or the agent may feel that the sales targets are unreasonable and simply can't be met despite their best efforts. For example, there may be a target to open a certain number of new accounts within a territory, and the agent may say, well, there's simply within my territory, just it's impossible to target and reach that number of new accounts. So in that scenario, the principal should give due consideration to the agent's position before deciding on what steps to take. It's really important for there to be a two-way dialogue. So listen to the agent, reflect on the agent's feedback. Ask yourself, are the agent's points valid? Are there ways that we can support the agent to help them improve their performance? It's important the agent feels their voice has been heard, but equally that you've made your position very clear as the principal. What is it that's expected of them? How long do they have to show an improvement? How will this be measured and by who? And what will happen next? When will there be a follow-up meeting? So we recommend keeping a really good and accurate record of any performance review meetings and discussions that may take place. Keep notes and follow the meetings up with notes. Share those with the agent so everyone has a record of what's been discussed and agreed. And then the principal should implement a method of ongoing performance monitoring so that both the agent and principal know how things are progressing and the performance can be measured. However, if despite the principal's best efforts, the performance of the agent doesn't improve and the principal still has serious concerns about the agent's performance, then at that stage, again, it would recommend the principal seeks legal advice on the options available. And one of those may be including the exercise of the right to terminate the agency for serious breach. That brings me to the end of today's webinar, which I hope you found useful. And we'll now move on to the question and answer session. So if I can please ask you to add any questions that you have to the question and answer function, we'll answer as many of those as we can. And if you can just bear with us for a few moments, we'll just have a look at the questions and answer those in a moment.
Why are services excluded from the regulations? I think the answer really is that they just are. Interestingly, I think in other European countries, such as France, I believe, Suzanne, the regulations do cover agents who sell services, but for whatever reason, the UK legislature did not widen the coverage of the regulations to include services. It seems a bit unfair, but yes, when we're talking about commercial agents and regulations applying, we are really talking about the sale of goods, tangible goods, and there may be instances where there's a mix of services and the sale of goods, but ultimately the question is are the activities of the agent primarily focused upon the sale and marketing of goods? And if they are, the regulations apply. If they're not, then it would just be a matter of contract law, without the application of the regulation. So I hope that answers the question somewhat.
Thanks, Rob. And that seems to be the only question that we've got today, which is quite unusual. We're usually faced with a raft of questions, but thank you. I do hope that's been helpful, and we look forward to welcoming you back to the next webinar later in the year. Thank you.